Do not send me to jail. I would not put you here. I know you still got some type of love for me. You're not going to press charges, but I know you really don't want to see me rise in jail. You're going to send me to jail for 10 years. Me biting you in your spit on your face, that was just childish. I apologize. Yeah, Your Honor.
Let's select Senator Don Lipa on behalf of Mr. Larry.
Hey,
Larry.
thank you. You're looking for an adjournment.
I am, Your Honor. We're requesting some media.
You may.
Your Honor, give me my attention. While the defendant was in custody, he made 3 calls to the victim from his PIN to her listed number. In those calls, he says things like, I'm in jail for 3 days, I've been here every day. What his bond is set at. He also states things like, we really get cut all that shit out. We can go our separate ways. Do not send me to jail. I would not put you here. I know you still got some type of love for me. You're not going to press charges, but I know you really don't want to see me rise in jail. Might not want to talk with me, but I don't believe that. Right, so you're about to keep me in jail for real. You're going to send me to jail for 10 years. Me biting you in your spit on your face, that was just childish. I apologize. Talking about the case, talking about you're keeping me in jail. Are you really going to press charges on me? And so at this point, I'm going to ask him if you're going to he violated his bond. He's called for it after he was arraigned and told not to have contact with her. And he did have contact with her. Talking about the case, talking about keeping him in jail and like that. So I have concerns. And ask him to hear me that started to violate his bond.
Response, Mr. Allen.
Your Honor, Mr. Larry's indicated to me that these calls would have been made prior to the arraignment. I understand.
It would have been made prior to his arraignment?
That is what Mr. Larry's indicated to me. I haven't been able to verify that myself.
What's the date of the calls?
The calls are from 3/26. Along with one on 3/25 that was later in the evening, after he would have been arraigned.
I did discuss it with Mr. Larry. He does understand that.
Still want to keep representing to the court that they were made prior to his arraignment?
Yeah.
What?
Oh, Your Honor.
Yeah, because that wasn't true. All right, go ahead, counsel.
Your Honor, all I can say is that Mr. Larry did indicate to me that he believed they were prior to his arraignment. I'm glad that he's...
Seriously? No, he didn't.
I'm glad.
Just saying that.
Yes, I'm glad.
He just got you to just say it.
Yes, and I'm glad that he's now come clean about that. He certainly understands that he cannot have contact.
She has to check any text. Wait a minute.
It's not helping.
Anything else?
I have nothing to add, Your Honor.
People's motion to modify bond. It's granted. Defendant's bond is hereby ordered above. Defendant's remanded back to the Washington County Jail. Court, they will also order that his phone privileges and texting privileges are hereby ordered above. Defendant's remanded.
Thank you, Your Honor.
This first hearing becomes much more serious because of the alleged jail calls. The court had already ordered the defendant to stay away from the alleged victim, but prosecutors say he used his jail PIN to make calls about the case. He allegedly asked if the victim would press charges, apologized for biting her face, and begged not to stay in jail. Those calls are important because the no-contact order was meant to stop this type of communication. Then another problem appeared. The defense first said the calls happened before the arraignment. But once the dates were checked, that explanation did not match the timeline. The defendant apparently admitted that his earlier statement was not true. That left the defense with very little to argue. Judge Simpson then granted the prosecution's bond request and removed the defendant's phone and texting privileges. The message from the court was clear. If you are given rules, you are expected to follow them.
How's the case? People versus Wardell Smith.
Morning, Honor. Wardell Smith, who's approaching the podium. Wardell, would you state your name for the record? Wardell Smith Jr. Judge, this is a PCC matter. I've had a chance to speak with Mr. After discovery. We're asking you to sit for an exam.
All right, preliminary examination will be set for, will people have their witnesses available the 14th? Set preliminary examination, April 14th, 2026, 9 a.m. That is before Judge Moore.
Judge, may I address bond?
Well, both of you want to address bond.
I think I should go first.
Why is that?
Because I know what she's going to say, so I want to beat her to the punch.
Okay,
Judge, no, not to be facetious, but my understanding he's got a $50,000 10% bond. This is incident between he and his wife, a long-term marriage. My client is asking that if the court would consider a $5,000 10% bond tether if necessary. He's the sole support of the family. He will stay away from the marital home as for now and wants to help work with his children. His daughter's graduating this soon. He wants to be able to be there. So what we're asking for is a reduction in bond.
Response, I guess.
My attention that Mr. Smith has made, I believe, by the last check was 65 calls to the victim's listed number, which we have had contact for from his PIN since being arraigned in the jail. I and for phone privileges and text privileges to your votes in those calls, there in terms of giving I love you, babe, things like that. So it's a pretty good idea that it's Mr. Smith and would have to your vote this time for bond remain set, given that he has violated that bond.
Judge, if I may, I thought when I got the appointment, I was told he was out of custody. I did call the one number. It ended up being his wife. She then texted me saying that she would like him home. I told her I can't speak with her anymore about that. That's something for her to discuss with the prosecutor. But again, Your Honor, we're asking if you would please consider a reduction bond on tether.
I'm going to deny the request. He's violating the conditions of his bond, or at least an indication that he has. So I'll deny the request for any reduction in bond. Bond will continue. Defendant's phone privileges and texting privileges are hereby ordered to revoke pending a hearing.
The Smith hearing shows how quickly a strong bond argument can fall apart when the defendant is accused of breaking the court's rules. The defense gave several reasons why Smith should get a lower bond. He has been married for a long time, has family responsibilities, provides financial support, and was willing to stay away from the marital home. The defense also offered GPS monitoring as an option, but prosecutors brought up one major problem. About 65 calls were allegedly made from Smith's jail PIN to the protected person's number, even though there was a no-contact order. Even messages like, "I love you," do not fix the problem. A no-contact order usually means no communication at all, whether the message is angry, threatening, or loving. The fact that his wife reportedly wanted him home may explain the family situation, but it does not give Smith permission to ignore the court's order. So the focus quickly changed. Instead of asking whether a GPS tether could control future risk, Judge Simpson had to consider whether Smith was already refusing to follow the court's instructions.
We're on behalf of Mr. Thomas.
Your name?
Everyone Thomas. Thank you, Judge. Today is a date and time set for a probable cause conference. We are asking that we are trying to get Mr. Thomas into recovery court. He was denied from 14A and then 15th District on basically technicalities as far as admission. We're trying to get him in a 14B, so we are asking for an adjournment at this time.
Why is he testing positive for THC?
He has a medical card, Judge, which he has brought with him today.
Did he give that to them?
He did at the time of his test, but they declined to accept it. They said they didn't need it or didn't need to see it. He does have it with him present today.
All right.
Thank you, Judge.
What are you looking to do?
We're looking to adjourn it out to allow us time to get him screened for the 14B recovery court.
23rd, 2026, 9 a.m. Bond.
Thank you, Judge.
Enough people on both cases.
Good afternoon, or good morning, Your Honor. Marcia Craig on behalf of Ms. Sanders.
What?
Good morning, Your Honor.
Oh.
I'm excited.
Out there, you explored the world, thought the place was better than Washington County, and you're back.
Yeah, it was a long journey, Your Honor. But I'm glad to be back. I'm so happy to be back.
It's like Groundhog Day. It's just going to repeat itself.
Hi.
Well, it's good to have you back.
Thank you.
Your name, ma'am?
Chardonnay Sanders.
Thank you. You need an adjournment?
Yes, please, Your Honor, to making sure I have all discovery and then to share that discovery with my client. Additionally, my client is...
The ninth work for you?
I'm sorry?
The 9th work for you?
Yes, it will, Your Honor.
Probable cause conference will be adjourned April 9th, 2026, 9 a.m. Bond.
Well, my client's asking me to make a bond modification argument, Your Honor.
Okay, go for it.
Okay, thank you. My client's currently charged with 2 cases that are very serious. She understands that, but those are allegations. She'd like me to relay to the court that she's lived in this county her entire life. She has some children that she needs to ensure that are being taken care of. During this time, she has been working on her case service plan for her neglect and abuse case, and she's doing well. She does not have a job at this time, so the bond amount that in each case is a financial hardship for her. She's willing to do a GPS tether. She understands that she needs to come back to court, and she has family in the area that she could stay with and support. So we're asking to lower the amount to a PR if possible and or a 10% component, Your Honor. Thank you.
Sponsor the people.
And I would ask the bond to be the same. She failed to appear on the child abuse case and this court. The second charge, she got picked up and she's here before you was assault, probably harm, murder. She allegedly stabbed her mother's girlfriend in the arm, causing a lot of damage.
My client tells me that she had her cell phone stolen from her, and that's why she missed her court date, Your Honor.
Okay. Thanks for letting us know. Given all those circumstances, I'm not going to reduce her bond. Her examination is coming up, and we can certainly address it at that point in time after the testimony is heard. Motion for bond reduction is denied.
Thank you, Your Honor.
Across these hearings, Judge Simpson keeps coming back to the same basic idea. Getting more freedom before trial becomes much harder when there are questions about following court orders or managing risk. Larry's situation became worse when the timing of his calls did not match the dates presented in court. That led to a bond change and the loss of his communication privileges. Smith asked for a major bond reduction. His defense pointed to his family, financial responsibilities, and willingness to wear a GPS tether. But prosecutors pointed to roughly 65 calls to the protected person. That gave the judge a serious reason to keep the bond in place and remove phone and texting privileges. Thomas had a different situation. His THC test was explained by his medical card. His attorney also asked for more time to work on recovery court, and Judge Simpson granted the adjournment. Then there was Sanders. His defense asked for a lower bond because he had local ties, children, financial problems, and family support. He was also willing to accept GPS monitoring. But prosecutors focused on the serious charges and the allegation that a stabbing caused significant injuries. Judge Simpson refused to lower the bond, but said the issue could be looked at again after testimony during the examination. That is an important point. A bond hearing is not a trial. The judge is not deciding whether someone is guilty. The judge is deciding whether the person can safely remain out of custody and whether the proposed conditions are enough to manage the risks. Which argument do you think was the strongest? If this courtroom case surprised you, hit the like button, share your thoughts in the comments, and subscribe for more courtroom breakdowns.